G'day, I'm Stephen Page from Page Proven Family and Fertility Lawyers, and you're watching and listening to the Australian Family and Fertility Law Podcast. What I want to talk about today is a recent decision in July from the Supreme Court of Mexico, which in my view puts Mexico really much more comfortably as a place to do surrogacy. There are two ways to achieve parentage via surrogacy in Mexico, and I've talked about this in a previous video. One is the old-fashioned way. Surrogate goes on as the birth mother and the biological father goes on the birth certificate as the parents. The other way is to get what is called an amparo order, and amparo, A-M-P-A-R-O, is not there's no direct translation from Spanish to English, but in essence it means constitutional protection, whereby the intended parents, once they get the order, and it can be made before the birth or it can be made after the birth, are recognised as the parents and therefore on the birth certificate as the parents. What the Supreme Court has said in a case from the state of Jalisco is, well, we called on the Congress, if they could, to regulate about surrogacy, and they haven't, so we're going to do it. And they're not doing it about the old-fashioned way, but they're doing it, if you want, an amparo order. So they're setting out by judicial decree, in effect, here are the guidelines that you must comply with if you want to get an amparo order. And there's one restriction, but overall I think they're really good because they're really about protecting the surrogate. If we look at previous history of the Supreme Court of Mexico, there was a major decision in 2018 that said, in effect, families come in all shapes and sizes. Families are no longer restricted to husbands and wives having sex together and then creating children. IVF came along, and then of course we got single women, single men, and even lesbian couples and gay couples having children, and they should all be recognised. And the court on that occasion said who are the parents, and this has led to amparo orders, are those who intend to be the parents, and those who are not are those who do not intend to be the parents. This is in the context of surrogacy, of course. And in 2021 there was a decision that said, well, this human right to recognise those who need to undertake surrogacy is not limited to Mexican citizens, but also to foreigners. So foreigners have the same human rights in Mexico as Mexicans. Great. This one is mainly focused on the rights of the human rights of the surrogate, but also in one respect as to the child. And I think this is a good thing. The overall rule is, if you've got a surrogacy agreement in Mexico, it cannot be oppressive of the surrogate, because if it is, well, you're out of there. You will never get an amparo order. And subject to that, there are some things that the Supreme Court has said are pretty obvious in terms of upholding the human rights of the surrogate. Number one, before she signs up, independent legal advice. Great. Number two, before she signs up, independent counselling, so she can have that psychological support. Marvellous. Next one, before she signs up, independent medical advice, so she goes to a doctor and she can get this obstetric advice about risk to her. Wonderful. And on the way through, that she has access to counselling support, and when the amparo is granted, that she has her own independent legal representation. Because in that case, she didn't. Somehow, the lawyer who was acting for the intended parents also thought it was appropriate to act for the surrogate. Well, of course, if she has a different view, she doesn't have independent representation. The lawyer's conflicted. So it was really good that the Supreme Court has said that. The Supreme Court then went through particular clauses of the agreement in question and said, yes, this is okay, no, that one's not. But those are the broad general rules, and one restriction in terms of the child. That is, there must be a genetic connection between one of the intended parents and the child. So this means that If you don't have a genetic connection as intended parent with the child, can you do surrogacy in Mexico? Yes, you can still do surrogacy in Mexico if there's only one of you, or if there's both of you and there's no genetic connection, you can still do surrogacy there. But you won't get an amparo order. You'll have the old-fashioned way, which is biological father and, in this case, non-biological father might be just the surrogate on the birth certificate. So you obviously want to get advice about that. You may, in those circumstances, consider going somewhere else other than Mexico. These changes will it make any difference, significant difference in price? No, not that I think of. But what they will do, in my view, is really reinforce protections for the surrogate, and that's a good thing. With all the challenges that we've seen in the world about surrogacy and the risks of surrogates being exploited, it's marvellous that the Supreme Court of Mexico has done this. I think it's such a wonderful step. Thank you for watching and listening. I'm Stephen Page from Page Probe and Family and Fertility Lawyers, and this is the Australian Family and Fertility Law Podcast.